Welcome to Vishnu Consultants. In this video, we will learn some important information on environmental law. Protected forests are of two types, demarcated and undemarcated. They have a limited amount of protection. These are looked after by the government by certain activities like hunting, grazing or timber collecting are allowed to people who live on the boundaries of forest and are partially or wholly dependent on the forest resources for livelihood, provided they don't cause severe damage to the forest. Village forests are protected and managed by village communities, which are assigned by the state governments. The local communities may use it for timber or other forest produce, pasture, recreation, plantation, and so on under prescribed conditions by the state government. Reserve forests constitute more than half of the total forest area of India. It has certain degree of protection. They are protected by the respective state governments, unlike wildlife sanctuaries and national parks, which are supervised by the government of India. It is considered as most valuable type of forest from the perspective of conservation. Rights to activities like collecting timber or grazing cattle or hunting and public entry are banned in these forests. Section 2, Clause 37 of the Act defines wildlife as wildlife includes any animal, bees, butterflies, fish, and moths, and aquatic or land vegetation which forms part of any habitat. So, the meaning of wildlife in this Act is very wide and inclusive of all kinds of flora and fauna. In 1973, the Endangered Species Act was enacted to stop the extinction of many species of wild animals and plants in the United States, other nations, and at sea. It provided mechanisms for the conservation of ecosystems on which endangered species depend. It also discouraged the exploitation of endangered species in other countries by banning the importation and trade of any product made from such species. Of critical concern was the loss of biodiversity through species extinction. This is an irreversible process and a fundamental environmental problem. Marine life is an asset to our environment, which has a huge contribution towards maintaining the environmental ecosystem as well as the economic prosperity of a country. But in recent years, due to waste, dumping, and pollution by scientific means, lack of awareness and consciousness, marine life is in danger, especially because this is a source of income of many people who are engaged in illegal trade. Hence, it becomes our responsibility to protect and conserve marine life. We also need to address our lack of awareness and lack of consciousness regarding the protection of marine life. But we also not willing to protect and preserve it because we are trapped in a cycle of commerce and trade at the cost of damaging marine biodiversity. Currently, marine life protection is one of the main concerns throughout the world. Due to industrial and scientific pollution, marine animals are in danger. Not only this, but marine life is also threatened by the overuse of the food industry, medicine, energy, transportation, commerce, etc. Several international conventions have been passed in the last few decades to protect this life. Several non-profit organizations are working tirelessly toward the goal of protection of marine life. Even though they are trying their best, marine life still needs the joint efforts of the public and the state. It is extremely important that we recognize our responsibility towards marine biodiversity at the earliest. Animals, similar to human beings, have the capability of comprehending physical and mental pain. Therefore, they can understand the severity of any physical or mental harm that is inflicted on them. This earth belongs to them as much as it belongs to us human beings. Thus, it is imperative that other living creatures are allowed to live and thrive just like us. With this vision, the Prevention of Cruelty Act 1960 was passed, purporting to punish severely the persons indulging in cruelty against the animals, the establishment of an animal welfare board, identifying the acts amounting to cruelty against the animals, etc. Here are the silent features. In 1972, the Wildlife Protection Act was passed by the Parliament, which was more of a special enactment dealing with the protection of wild animals within the Indian territory. The Prevention of Cruelty to Animals Act 1960 prohibits any person from inflicting, causing, or if it is the owner, permitting unnecessary pain or suffering to be inflicted on any animal. The Act makes it a crime to beat, kick, torture, mutilate, administer an injurious substance, or cruelly kill an animal. It is also illegal to override, overdrive, overload, or work an unfit animal. It is an offense to cruelly transport, confine, chain, or tether an animal. It is a violation to engage in any animal fighting or shooting competitions in which animals are released from captivity to be shot. An owner commits an offense if he or she fails to provide sufficient food, drink, or shelter, unreasonably abandons an animal, or permits any deceased or disabled animal to roam or die in any street. The Water Prevention and Control of Pollution Act 1974 has been enacted to provide for the prevention and control of water pollution and to maintain or restore wholesomeness of water in the country. It further provides for the establishment of boards for the prevention and control of water pollution with a view to carry out the aforesaid purposes. The two main laws that regulate air pollution in India are the Air Prevention and Control of Pollution Act 1981 and Environment Protection Act 1986. This article is primarily concerned with critical study of provisions under these two acts. The term clean air means air which is clean, unpolluted, and neither harmful for humans nor harmful to the surroundings where we live. To maintain this, various countries in the world have their own laws. A state cannot ignore environment and only concentrate on economic growth. India is having worst environment among 132 countries according to Environment Performance Index. There are several factors degrading air quality of India. Today it has been a challenge to maintain clean air in most developed countries like China, etc. Smoke has been common in big cities. In Article 48A of the Directive Principles of Constitution of India, it has declared that the state endeavours to protect and improve the environment and to safeguard the forest and wildlife of the country, whereas Article 51A imposes similar fundamental duty to citizens as well. Hence, it is necessary to have good laws and mechanisms. In India, all pollution control measures are based on three major acts: the Water Act 1974, the Air Act 1981, and the Environment Protection Act 1986. Recently, pollution limits of industries have been tightened. Decades old and outdated norms have been updated. However, there are still gaps in the matching global best practices and control measures. The Environment Protection Act 1986 is enforced by the Central Pollution Control Board and the numerous state pollution control boards. The National Green Tribunal established under the National Green Tribunal Act of 2010, which has jurisdiction over all environmental cases dealing with a substantial environmental question, and acts covered under the Water Prevention and Control of Pollution Act 1974, the Public Liability Insurance Act 1991, and the National Green Tribunal Act. The Water Prevention and Control of Pollution Act 1974 was adopted by the Indian Parliament with the aim of prevention and control of water pollution in India. The environment has been defined as the outer physical and biological system in which man and other organisms live as a whole. Human environment consists of both physical environment and biological environment. Physical environment covers land, water, and air. Biological environment includes plants, animals, and other organisms. Environment defined under the Environmental Protection Act 1986, where environment includes water, air, and land and the interrelationship which exists among and between water, air, land, and human beings, and any other living creatures, plant, microorganisms, and property. It includes the complex physical, chemical, and biological factors surrounding an organism or an ecological community. Such factors act and interact with various species and organisms to affect their form, growth, and survival. Any unfavorable alteration of this environment is called environmental pollution. Air, water, land, radiation, and thermal are the common type of pollution. Article 48A of the Constitution of India: Protection and improvement of environment and safeguarding of forest and wildlife. The state shall endeavour to protect and improve the environment and to safeguard the forest and wildlife of the country. The fundamental duties of the citizens of India are enshrined in Article 51A of the Constitution. The article was brought in by way of the 42nd Amendment of 1976 to bring the Indian Constitution in accordance with the Article 21, Clause 1 of the Universal Declaration of Human Rights. While fundamental duties are unenforceable in courts, they are often resorted to the interpretation of constitutional and other matters. In the context of animal rights, the relevant clauses of Article 51 read as follows. Have a look. Article 31C was inserted in the Constitution of India by the 25th Amendment to get over the difficulties placed by judicial decisions in the way of giving effect to the directive principles in Part 4. It provided immunity from any challenge on the ground of violation of Article 14, Article 19, and Article 31, any law enacted for implementing the directives in Clause B and C of Article 39. The National Green Tribunal, established in 2010 as per the National Green Tribunal Act, is a specialized juridical body equipped with expertise solely for the purpose of adjudicating environmental cases in the country. Recognizing that most environmental cases involve multidisciplinary issues which are better addressed in a specialized forum. The tribunal was set up as per recommendations of the Supreme Court, Law Commission, and the India's international law obligations to develop national laws on environment and implement them effectively. The tribunal is tasked with providing effective and expeditious remedy in cases relating to environment protection, conservation of forest and other natural resources, and enforcement of any legal right relating to environment. The tribunal's orders are binding and it has power to grant relief in the form of compensation and damages to the affected persons. For more such educational content, subscribe to Vishnu Consultants.